In this edition of the podcast and YouTube channel, I'd like to talk to you about what happens typically at the beginning of someone's case. A lot of times people come to us and they are in a really desperate situation and they need urgent help. And they don't always understand kind of the timeline of how their case is going to go and what we can do for them. I just want to give you a kind of basic and common case scenario that we see week in and week out, month in and month out. And that's when someone comes to us with children. Typically they're smaller children, not teenagers, but sometimes it can be a teenager. And one parent wants to get some kind of custody of that child. It may be limiting the other parent from seeing that child. It may be stopping a parent from leaving the state or leaving the city with their child. Or it could just be simple custody and visitation. And the reason why that becomes so critically important is because a lot of times people don't realize that unless you have some kind of parenting plan, and I'll explain that what that is in a moment, but some kind of parenting plan in place that's signed by the judge, nothing can stop your ex, whatever, boyfriend, girlfriend, husband, or wife from taking your child and leaving, possibly leaving the city, the state, or even the country. I've had many cases over the years where people have split up, whether they're married or not, and they don't have any kind of documents that are signed by a judge that are filed in court. And, a fight breaks out between the parents, and one parent takes their son or daughter and just leaves. Maybe they move and move to California, or maybe they take the kids and they go to Florida. Wherever it may be, that happens a lot. And I'll get a call from one of the parents saying, well, I've called the police and the police won't do anything. And what I tell them is that that's because you don't have anything that's signed by a judge that's would effectively stop a parent from leaving the state with a child. And so the police, if they come, are just going to say, well, if you don't have a court order, not much I can do for you. So that's why oftentimes when a parent comes to us in the early stages of their case, they need to understand that they have to get a court order signed by a judge that really lays out in very precise detail what is and what is not allowed to be done by the other parent in terms of parenting, visitation, custody, where the child is and when. So if we don't have that signed document in place, we're really in a tough spot. And I always caution parents that they should get, no matter how well things might be going between the parents at the time, they really need to get that court order in place, filed, and they need to have a copy for their protection. Because unfortunately, even though things may be going really well one day, I've seen so many instances where a month later, 6 months later, things blow up. And without that document to protect you, you're really in trouble. And we can get that document signed by the judge within 2 weeks, normally, of filing in the court system. And again, I'm talking about a parenting plan. And if you're not married and you file to have a parenting plan established, it can take up to a year to have a trial. A trial is just like what you see on TV or in the movies, where a judge and possibly a jury, depending on what state you're in, will be the one to decide what happens with your children in terms of visitation and custody. So knowing that you have up to a year before you can get a finalized court order from the judge, that's a long time to wait. And obviously a lot can go wrong in that year. So what we always advocate and suggest is getting in and doing what's called a temporary orders hearing, or a TO. We call it TO or TRO hearing. And it's just a hearing that goes in front of a judge or a commissioner, depending on where you are. And you have to give a 2 weeks heads up or a 2 weeks notice, both to the court, so the court can actually get you into their system and get you a court date, as well as to your ex or to the other parent, letting them know, hey, I want to go into court and I want to get a custody order. And you have to submit all of your documents. They need to be filled out right, and they need to be filled out and submitted on time. Otherwise, you won't get your court hearing. And these court hearings are usually very brief. You don't typically get more than 10, 15 minutes at most. to state your case as to why you feel like your proposed parenting plan is the correct plan for your child. And I just want to touch briefly on this document that I'm referring to. It's just a very detailed document that lays out where your child will be living, who will be picking your child up or children up from school, what the visitation schedule is going to look like in terms of weekends, nights, holidays, birthdays. All of those things are going to be really laid out in great detail in this document. Okay. Now, you may be thinking to yourself, well, can other people, family, friends, coworkers, even neighbors, can they come to the courtroom and explain to the judge, what's going on and why your parenting plan is the better one for your child or for your children? And the answer to that's typically no. That's normally reserved for the trial. And so what happens is you submit documents called affidavits or declarations in advance. So when you submit that package of the parenting plan 2 weeks ahead of time, you also want to put in there an affidavit or a declaration, which is just a statement signed under oath by those people that may be good witnesses for you, which may be a neighbor, a coworker, a family, a friend. Those can all be submitted to the commissioner or the judge 2 weeks ahead of time. So that way, when you go into the courtroom with your lawyer, the commissioner or the judge normally has a pretty good idea of what's going on in the case. So that's why you don't get hours or even days like you will or would at trial to explain your case, because by the time you submit all of those documents ahead of time, the judge or the commissioner should have a pretty good idea of what's going on in the case and what you're looking for. So you'll go into this hearing, again, once you submit all the necessary documents, once you serve, meaning you give a copy to your ex or the other parent on time, 2 weeks ahead of time, you'll go into that courtroom. And sometimes it's on Zoom, sometimes it's in person, just depending on where you are and what county you live in. But you'll go in there, you should have a lawyer with you. You need a lawyer to really fight for you on these because they're not easy. And as you can imagine, your ex or the other parent of the child also has the opportunity to respond to what you wrote, and they get to put forth their own documents explaining what's going on in the case as far as they're concerned and what they feel like is best for your child, right? So that gets filed with the court as well. And that's why it is so critical that you have a lawyer there with you who can, on the one hand, argue for you and convince the judge or the commissioner why your documents and the things that you're requesting are the best thing for your child. And then also your lawyer can frankly attack your ex or your other parent as to why their plan is not best and is not the best thing for your son or daughter or your children. So that's kind of from just a procedural standpoint how these cases go. You get a court date within 2 weeks, you get the documents filed on time and filled out correctly. You give your ex or the other parent an opportunity to review those and then submit their own documents. And then you go into the courtroom and you have an argument. And you let the judge decide or the commissioner decide as to what is going to happen with your child between that 2 weeks that you filed and when you have your trial. Which again, that could be easily 10, 11 months, maybe even longer. Again, normally a trial is within a year of when you initially file your documents in court, but sometimes the courts get busy. Sometimes if there's an attorney on the other attorney may not be able to make that date work with their schedule, and the trial gets pushed back. So you could easily have a year to a year and a half of waiting to get a final court order. Now, this is obviously assuming that you and the other parent or you and your ex can't come to an agreement amongst yourselves. You certainly can, and you can get those documents finalized and signed with the court at any time in the process. But if you and your ex or you and the other parent are completely at odds with each other and you're fighting the entire time, that's why it's so critical that you get that what's called that temporary order early on in the case. Because again, you could have up to a year of waiting before you get a final order. So it's not good to wait that long. You need to get that order in place to protect you while the case hopefully resolves within that time period. A final thing I want to note is that, if the judge agrees with you, or unfortunately, if the judge agrees with your ex, either parent, as to what that parenting plan and what visitation and custody should look like, in my experience, it's pretty rare that the judge that's actually going to have your trial, if it goes that far, will completely disagree and overturn what the first judge or commissioner did. Because a lot of times they're different people, right? And it's just because I think that it's one of those things that unless one side or the other can convince the judge that the original decision was horrible for their client or for you or for the child, the judge isn't going to want to step on the first judge's toes and say, that judge made a mistake. It does happen, don't get me wrong, but it's rare. So I think going into that hearing, even though it may only be a 10 or a 15-minute court hearing, it's really important because that kind of sets the stage and sets the tone and really lays the foundation of what is likely going to happen down the road at trial. So it's really, really important that you find the right lawyer ahead of time, that you get the right evidence submitted ahead of time. Like I said, those can be affidavits or witness statements. It could be emails. It could be text messages. You really need to get all of that gathered up and done right when you submit your parenting plan into court. Because again, if you get a bad outcome at that court hearing, it's going to come back to haunt you probably later on in your case. I hope that I've kind of given you an understanding, just a basic understanding of how cases work from the very beginning and how really important it is that you get the right lawyer who understands strategically how to get these documents submitted and get the right evidence for you so you can have a successful outcome for your case. If you have any questions or comments or concerns about what you've heard today, hope you can reach out. Hope you feel free to reach out, I should say. We'd be happy to talk to you and answer your questions and come up with a game plan of how we can help your case. So until we speak next time, I'm Chris Jackman from the Aberdeen Law Firm, and I hope we can help you soon.